Welcome to the Voice of Law podcast, brought to you by digital health think tank and ClearPoint Legal. Hosted by lawyer and philosopher Bianca Rose Phillips.
Hey everyone, it's Bianca here. Hope you're all keeping well. Welcome to episode 10 of the Voice of Law podcast. We are exploring the digital health revolution, establishing some context before we start to dive deeper into the law and the conceptual frameworks for lawmaking in the field of digital health. I want to start today's episode by thanking you all so much for tuning into this podcast each day, for sharing, for liking the podcast, and for your comments and feedback. For those who are new to this podcast, if you find the episode helpful, if it adds to your day, please share with your friends and colleagues. Now, yesterday I mentioned potential uses of voice technologies to improve the healthcare experience for both patients and clinicians. Today, I want to continue that discussion of potential use cases for voice technologies, but in the context of an embryologist completing a task such as assisting with in vitro fertilization, running tests on embryos, and maintaining clinical records. This case study may also have relevance to scientists who are undertaking clinical research and making observations. Now, I view the processes that an embryologist undertakes as being quite complex. Perhaps an embryologist themselves or a scientist would not view it that way, but from my perspective as a legal researcher and a lawyer, I think it's quite complex, and certainly there is a lot at stake for the patient. Okay, so let's imagine the following scenario. A patient called Jane had undergone an IVF cycle, and a number of her embryos underwent genetic testing. The testing involved biopsy of trophectoderm cells at day 5 in her particular situation, and the embryologist recorded the steps that he had undertaken using the VA that sits on his desk in the lab. The VA records a transcript of exactly what the embryologist has said. That information is maintained by the lab, but it is not integrated into the lab's patient portal. The patient portal, however, does permit each patient to view his or her lab test results. Jane and her husband did not check the lab portal prior to their appointment with their IVF specialist to receive the results. And they're sitting in the office. The doctor prints out the lab results, hands a sheet of paper to them. They look down and see that the result for one embryo reads no result and no DNA present. The physician looks at them and says the lab messed up. He immediately calls the lab to demand answers. Whilst the patient and the husband are in his presence, he speaks with a representative who informs him that although they maintain certain internal notes regarding the genetic testing they perform, those tests are not a part of Jane's medical records, and they are only permitted to provide access to lab results that inform the patient's medical records. Jane and her husband return home, and on reflection, they decide that they want more information. They submit a records access form to the lab and receive only the test results, not the commentary recorded by the VA. Okay, that's the scenario. Now, I heard of this case example when I was undertaking my Masters of Law program. As I mentioned in a previous episode, in this Masters program, I was studying with doctors and lawyers, so I heard many different case examples provided. The case example, when it was told to me 8 years ago, did not include the use of voice technologies, and obviously the processes of actually testing embryos has changed since that time. So I have adapted the scenario to be more relevant to what is possible now and in the future. In this particular scenario, the matter did not go to court. However, the scenario has really stuck in my mind over the years, and that's why I included it, and Heather and I included it in our book chapter, The Laws of Voice, for the Voice Technology in Healthcare book. And I think there are several reasons why it has really stayed with me. Firstly, I have really wondered what happened here. Why was there no DNA present? Doesn't really make sense to me, being a lawyer. If there's an embryologist or an IVF specialist or a doctor wanting to chime in about how this could possibly happen, I would be very interested to understand that. Secondly, the fact that the patients could not access that information regarding the process that was undertaken to determine if something went wrong and exactly to even get some peace of mind. The fact that that wasn't a right, an automatic right that they had, and that they had to go through a process of requesting access. And if details were not really provided in the medical record that they were given, to then have to seek further explanation and clarification is such an ordeal for patients. And next, over the years, I've also been thinking about, whether people may behave differently if they know that the patient, as of right, could access the information. Would they record it differently? It would be very interesting to actually have a look at, since we have granted access to patients to their medical records, even through a request to access their medical records, have behaviors shifted? Have practices changed with time? That would be a really interesting point of discussion, I think. And then as we move further towards this notion of patient control, patient access, or even maybe one day ownership, again, how will behaviors shift, if at all? It's just a hypothetical that I'm putting out there just to think about. And also, will we ever reach a point where there are standards on how information is described? I mean, we know that there are standards like that already in existence, but then to take it one step further, the law then going on to prescribe the types of information that must be shared with the patient, maybe more specifically than is done so today. So that is the scenario. I added the dimension of voice technologies, and there are some legal barriers towards seeing this actually done in practice. In terms of actually being able to convert voice to text, there really aren't that many barriers at the moment to do that. I mean, a lot of clinics already practice that, but it's the step of loading it onto a patient portal that adds to the complexity. So there are privacy and security laws. For example, in the USA, this includes HIPAA and state laws. And if you're interested in an overview of some of those relevant laws, I will link an article to this podcast episode. Let's think about this scenario for a moment. We're adding the voice dimension, and voice is very natural. If you had the ability, let's say, to record with your voice your processes, your observations, maybe even your thoughts, would more information be captured than would otherwise be done so with a written record? Now, I don't have the answer to that question. There might be someone out there who could put forward a hypothesis. Perhaps we need more research to support any hypotheses that we may draw in this instance. But I'm very interested to hear if there's anyone out there with thoughts on that point. Will we capture more information? Are people going to modify how they speak? These are, I think, valid questions. And if you would share more with a voice assistant or a voice technology, what are the legal issues that may exist? More specifically, what are the legal issues that are going to arise from a shift of paradigm, a shift from the way that things are done today to the way that it could be in the future? So, for example, if we believe in patient empowerment and if we move even further towards patient control of data, does that mean that all information, all thoughts, all processes of a doctor or a scientist or an embryologist or other health care provider, will that go to the patient as of right, once recorded with a voice assistant or once typed? However the input, will it go to the patient as of right? Or should the law exempt certain particulars from being provided to the patient? Now, this really goes to the question of who owns the health information, and a theory called the bundle of rights conception of ownership that was posited by theorist and lawyer Tony Honore. Ownership will be the focus of a few episodes on this podcast next week. It's a big topic. I want to really dive into it, and I want to consider it from various different perspectives as well. Okay, so there are some big questions to ponder over the weekend. Please feel free to get in contact with me via LinkedIn if you would like to add comments or ideas to this podcast. I would love to hear them. Next week, we'll have an entire week dedicated to unpacking the concepts that we have discussed in the first couple of weeks, where we have explored telehealth and voice technologies. If you're interested in learning about some more use cases for voice technologies, especially right now during the COVID-19 pandemic, there is a webinar that I listened to talking about how voice technologies can help with the COVID-19 pandemic, which I will link. It was fantastic. And I really recommend that you have a listen to that over the weekend. So I'll link it to this podcast. Have a wonderful Friday. Have a great weekend. This is really a challenging period for everyone. We just have to have so much gratitude to all of the amazing healthcare workers out there and all that you do for our communities, and to my friends and colleagues who are actually looking after patients right now. I admire you, and keep well. I hope that today's episode has provided a dose of inspiration and knowledge, and I look forward to next week. Thank you. Bye.